Welcome to the Virtual Spring Meeting 2020, brought to you by the American Bar Association Antitrust Law Section. The Spring Meeting is the section's premier event, a multi-day celebration of learning and camaraderie. The Virtual Spring Meeting brings together the world's leading experts on competition, consumer protection, and privacy law, discussing the most compelling issues of the day. Enjoy the show.
Hi, and welcome once again to the Virtual Spring Meeting. My name is John Roberti. Today, we have another great panel. This one is a spring meeting favorite. It is Hot Topics. With me today to provide some context and maybe some analysis are two of my co-hosts from the Our Curious Amalgam podcast. Matthew Hall is a partner at the McGuire Woods law firm in London. Hi, Matthew.
Hello, John. It's good to be here and good to see you live.
Good to see you as well. And Christina Ma is an associate at the Wachtell Lipton law firm in New York. Hi, Christina.
Hi, John. Thanks for having me.
All right, so let's get right into it. We're going to take it down to Brian GRUBE and Renata HESSE to kick off the panel, and then we will be back when they're done and talk a little bit about what we learned. Renata, Brian, take it away.
Thank you, John, for the introduction. Before we jump into our discussion on today's hot topics, I'm going to take a moment to introduce our speakers and my co-moderator. Our first speaker is the Honorable Rebecca Slaughter. Rebecca was sworn in as a commissioner at the FTC on May 2nd, 2018, nearly 2 years ago, where she continues to serve today. A native New Yorker, before she joined the FTC, she served as chief counsel to Charles Schumer, the senior US Senator from New York and the current Democratic leader. There, she advised Senator Schumer on legal, competition, telecom, privacy, and consumer protection issues, among many others. And before that, Becca practiced in the DC office of Sidley and Austin. Next up is Kent Walker, Senior Vice President of Global Affairs at Google. Kent has spent more than 20 years working at the forefront of technology, policy, and legal issues. In his current position, he oversees Google's legal, policy, and compliance affairs, product policies, philanthropic efforts, and works with governments around the world. Before joining Google, Kent held executive positions at a number of leading technology companies, including eBay, Netscape, and AOL, among others. He also served as an assistant US attorney with the DOJ and advised the Attorney General on technology policy issues. My co-moderator today is Renata HESSE. Renata is today a partner at Sullivan and Cromwell in Washington, where she is the co-head of the Antitrust group. Before that, she had an illustrious 15-year career in government, twice serving as the acting attorney general in charge of the Antitrust division at DOJ, and also serving at another time as a senior counsel to the chairman of the Federal Communications Commission, where she advised the chairman on transactions pending FCC approval. From here, I'll turn it over to Renata.
Great, thanks, Brian, and welcome everybody. I get to the distinguished honor of introducing Director General Olivier GUERSENT, and I want to welcome him to what I believe is his inaugural spring meeting. We're extremely grateful that you're able to join us, particularly in these unusual circumstances. Olivier has had a long history with competition issues in his work at the European Commission, starting with DG Comp and the Merger Task Force in 1992. He has since held a variety of positions in and out of competition, including in cartels, policy coordination, and merger control. He became the Director General of the Directorate General for Competition on January 1, 2020. I also have the honor and privilege of introducing Bruce HOFFMAN. Bruce is currently a partner at Cleary Gottlieb, having joined the firm from the Federal Trade Commission, where he was the director of the Bureau of Competition from August 2017 to December 2019. Bruce also served at the FTC from 2001 to 2004, starting as associate director for regional litigation, and then being elevated to deputy director of the Bureau of Competition, which is where I first met Bruce. I'm going to throw it back to Brian to get us started.
Let's jump right in. Today, it goes without saying, no topic is more pressing than the global coronavirus pandemic. That we're conducting this program online rather than in person with our audience is but one very modest example of the impact that it is having on our daily lives. This is certainly also true at the world's competition enforcement agencies, where Becca and Olivier, you both have been overseeing a number of initiatives that the agencies have launched to confront and manage this pandemic. Becca, if I could start with you, could you please let us know some of the things that the Commission has been doing to deal with the coronavirus, and perhaps also what's been working well and what still might need some work?
So thanks so much for having me, and thanks for the question. The way I think about our coronavirus response, I put it into two buckets. The first is, how are we adapting the business of the agency to the new circumstances in which we all find ourselves? And the second is, what specifically are we doing to respond to the coronavirus pandemic? So on the first topic, I will say there has been a really heroic amount of work and effort on the part of our staff, our IT staff, folks across the agency and the agency leadership to get us up and running from a telework perspective. We had some pretty good telework capabilities to begin with, but it has still been a huge amount of effort to put everybody, give everybody the tools they need to do their work from home. So that has been very impressive. We just started accepting HSR filings electronically, for example. And we are, I think the approach that we're taking is that we will in no way relax the standards and the expectations that we have of rigorous analysis in the course of the ongoing work that happens during the pandemic. That said, I think it's important to note that this is really hard. It's really hard for staff. I know personally, trying to juggle my job with 3 little kids at home and keep them on their distance learning, that I feel like it's impossible for me to devote the kind of attention and energy full-time to my job the way I want to be and normally am. And I can't imagine, as heroic as our staff is, that many of them in similar circumstances are facing things differently. So I think it's really important for parties that are filing with us, parties that have cases before us, to understand that sometimes things may take a little bit longer. Sometimes the processes may work a little bit differently. We can't sacrifice our standards. So we need to be more flexible with time and more flexible with some of the patience that we give to everybody. And I think the agency has been pretty clear that we're not going to relax standards in that respect. Then in terms of what are we doing specifically to respond to the crisis, I actually think this is a really important moment for us. On the consumer protection side, there's some very obvious responses. We're dealing with scams, we're dealing with fake cures, we're dealing with, donation scams, things like that. So I think that that's really important. But I also think this is a moment for us to step back and think about our supply chain issues that we're seeing. I think we need to be particularly vigilant about merger defenses, such as failing firm defenses. I will say we've had a run of failing firm defenses that the Commission has not found particularly persuasive before this crisis happened, and I would expect us to see a lot more of those coming up. And I think we can't relax our standards. And in fact, I think we need to use this moment to identify priorities in terms of protecting supply chain, protecting procurement issues, making sure that our markets are working better. Because if we've seen one thing in the first couple of months of this pandemic, is that we have a lot of issues underlying how we're sourcing and getting or not getting important medical supplies. And we would be remiss if we didn't take the opportunity to look at that seriously.
If I can put one follow-up question to you, Becca. I mean, among all of the things that you've identified and you've said the Commission has been having to deal with, what perhaps has been the most surprising issue for you, something that you didn't expect under the circumstances?
I think there've been a lot of surprises for everybody recently, and we've all learned a lot. I think I will answer that question with a more personal answer than a substantive legal answer, because I think there are a lot of good substantive legal answers. But one of the things that's really been striking to me is just how challenging this is. Even as a person, I speak as a person of incredible privilege and luck in this situation. I'm healthy, I'm employed. I feel enormously grateful that I don't have any of what I think of as the very serious, real problems that so many Americans are facing right now. And it's still really hard. It is really hard to juggle the demands of family and work and the sort of generalized anxiety that we're all feeling. So that makes me feel, I raise that because I know that if I am feeling that way, I'm sure many other people are feeling that way. And I think it is a really important moment to have a lot of empathy for what everybody is dealing with, even where what you're dealing with is not the obvious, real, life-changing challenges that people have. But I will pair that with a compliment to the chairman and our agency leadership, because I think everybody within the agency has been working really hard to acknowledge the burdens that we have on our staff right now and how hard the staff is working to do the best they can under the circumstances. And the chairman has been really great about being as accommodating as possible. And I think that deserves a lot of credit. So because ultimately an agency is made up of real people, and real people have real lives that they have to contend with, usually outside of work, but right now at the same time as work. So I think that's my biggest surprise.
I don't think you're going to find any dissent among our speakers here today. Turning to you, Olivier, this is obviously not a problem that is unique to the United States. What types of issues is the EC having to deal with, and DG Comp in particular?
Well, thank you. Well, first of all, very glad to be back home in the competition world. It's not exactly my first ABA, Renata, but it's definitely my first ABA as Director General. I've got many either as participant or attending, simply going along with former commissioners. Very happy to be here. Yeah, it's quite challenging time. I mean, like Rebecca, the staff of DG Competition, nearly 100% is working from home. Actually, at the moment in the European Commission, we have 32,000 people teleworking. And we have, it was a bit bumpy in the first 3-4 days, but now it's okay for a number of weeks. And I'm amazed that we can do exactly everything we were doing in the office from home in terms of processing merger cases, for example, processing all the procedures. It's a real life test that it can work. Of course, it takes a lot of dedication for the people of DG Comp. And I just want to have a specific word for the colleagues of the IT, because they're actually the only one that are physically in the office. Because when you have to repair a connection, you cannot do that distantly. So these colleagues are actually working in the office. And I'm going in the office occasionally. There's a few number of things I cannot do distantly. Now, if I go to, it has been exceptionally busy time. I mean, we are now in our 6 weeks of being home. We think we will start to go back to office as of May 4, but probably in very limited numbers. And most of the colleagues will continue to telework. The central services of the Commission are still mapping out how we will go back to work, but it will be a high number of weeks before if we ever are like before, we are like before. Maybe an outlook of the work. It's been 5 extremely busy weeks. I can't remember the last time I had a weekend, and a number of my colleagues are in the same situation. For us, this is mainly because we do something that none of you guys do. We control the state aid in the European Union. And of course, like in the US, like pretty much everywhere, the strategy has been to pool liquidity on firms so that they don't die and they're still there when we start returning to normal, in order to resume activity as quickly as possible. And that has involved the Commission to issue a specific temporary framework for state aids, which was a lot of work. We have currently more than 200 applications for individual notification within or outside of this temporary framework. And we have to date adopted, I think, between more than 60 individual decisions, plus the number of measures that did not require any individual decisions. So that was very, very intensive, but that's EU idiosyncratic, if I may say. A bit more generic, in the field of antitrust, and in particular cartels, we've done several things. So first of all, we have issued guidance for the first time since the new regime entered into force in 2003. And there is a good reason why we didn't do that before. It's because, as the oldest among you will remember, that before 2003, we had a notification regime in the EU, and we wanted to have a clean break in 2004. And we didn't want that lawyers continue to queue to get guidance instead of the clearance they used to get before for the notifications. So we said up front, we will not give any guidance. And we did so for more than 15 years. We were started to think about resuming some guidance business, in particular in respect to decarbonation of the economy and stuff like this, before the COVID. And COVID, of course, accelerated that trend. We also issued our first comfort letter for what I would not qualify as a crisis cartel, but a cooperation we would probably not have accepted in normal time among pharmaceutical firms in order to increase the output of crucial medicines for intensive care units, which are not in shortage, but there is a tension in the market. So there was a need to increase production by some 15 to 20%, and that could only be achieved by specializing the various production units, and that needed, of course, to be coordinated. So we have agreed to this, and we are closely monitoring it within the Commission. So that's quite important. We have also a number of requests for typical crisis cartel, and you will not be surprised, in particular in the agriculture sector, which, as you know, in the EU is under a specific set of competition rules. We've just issued the first decision in that respect, in order to manage the drop of demand for several key agricultural products. Turning to mergers, well, then it was pretty much business as usual, because, as I said, the informatic infrastructure we have allows us to deal with mergers the same way as we always do. The problem was more in the ability to conduct market investigations, because, of course, firms have the same problem we have, and they have many other things to do at the moment that answering requests for information from antitrust authorities. So it's very difficult to conduct a market investigation at the moment and have a satisfactory rate of response. So that is why we have dealt with the cases that were ongoing. We have slightly more deadlines that are suspended in individual cases than usually, because of the difficulties that notifying parties meet in answering detailed requests for information at the moment. Some of them completely emptied their offices, and it's very difficult for them to access some of the key documents that were not necessarily available online. So we have a number of stop the clock that is maybe a bit higher than would normally be the case. But otherwise, it's fine. We have posted a notice, and we'll finish with this, on our internet site in order to ask companies, to the extent it is possible, to delay the notifications. Not that we cannot deal with the notifications, as I just said, we can, and we do, and we issue decisions every day. But in case it's not a straightforward case, it is possible that we have difficulties to check the facts in a phase 1 investigation. And we wouldn't like that companies end up in phase 2 for that reason, because that entails considerable delays. And it seemed to us more reasonable when you cannot always, but when you can, to delay a few weeks the notification so that we are able to perform the normal market investigations, and only cases that deserve to go into phase 2 go into phase 2. Thanks.
Kent, we've spoken and heard from the government, but they aren't alone in this. And Google in particular recently announced that it has embarked on a joint effort with Apple to enable the use of Bluetooth technology to help governments and health agencies reduce the spread of the virus. What can you tell us about that project? And more substantively, how will Google and Apple plan to address the privacy and data security concerns that such an unprecedented initiative like that naturally might raise?
And all the government agencies are each doing what they can in their own ways. We pitched in with over $1 billion now in grants and loans and credits for small businesses and newsrooms and public health agencies. But as you say, fundamentally, we're a company that's founded on science and analysis. So that's been at the heart of our response. We've had over 2,000 different ideas come in from our engineers. We've had to create an air traffic control system just to try and sift through the different ideas that are coming in and see what could move forward on. That's everything from making sure we're continuing to provide high quality information and combating fraud and misinformation, the kind that Commissioner Slaughter was talking about a moment ago. Community mobility reports, which help public health officials track the success of social distancing measures, screening and testing sites, expanding our communications platforms as everybody from school kids to professionals to families trying to stay in touch are going online, working on PPE, using artificial intelligence to try and promote vaccine discovery through protein folding. And then most recently, as you mentioned, this exposure notification project that we've launched with Apple. As a background for folks who haven't been focused on this, public health officials have said that exposure notification is going to be a critical tool in helping to reopen the economy. Our joint effort with Apple uses Bluetooth technology, not location history, and it does it in a decentralized, privacy protective way so that users opt into the system and can control whether or not they keep using it. Nobody's identity is revealed to other users or to Apple or to Google. People who test positive aren't identified as such. So we think this is the right way to do this. And we've been glad to see the support from data protection authorities around the world who appreciate that privacy is central to this.
Okay, I think I'm going to pick up and move us into merger litigation and merger control. And obviously not everything has been stopped by the coronavirus. Even the courts managed to get some decisions out in antitrust cases. And as we know, courts are now starting to do oral hearings, or at least some of them are. But two cases in particular that I wanted to ask Bruce to comment on first, Fairlogic Sabre and T-Mobile Sprint, in which DOJ lost both of those challenges. Having recently stepped back into private practice, I wonder whether there are any practical lessons that you draw from those decisions. And more particularly, given, I'll say the somewhat idiosyncratic nature of both of those decisions, what effect, if any, do you think they may have going forward? There's lots of interesting language in the Sabre Fairlogic decision about two-sided markets. There's interesting material in the T-Mobile Sprint, Judge Marrero's decision about efficiencies. and the credibility of witnesses. So I'd be interested to hear, Bruce, your takeaway on both of those.
Thanks, Renata, and thanks, by the way, to the ABA for allowing this panel to go forward, for all the huge efforts that made this possible. A couple things about this. I think, first of all, it's important when you, well, first of all, in interest of full disclosure, my firm represented T-Mobile in that litigation, although I was not at the firm at the time. So I have a neutral perspective on it historically. I think it's important, a couple things are important about the cases. First of all, it's important not to overread results from a small number of cases. Merger litigation is not that common. There's not a huge number of cases, so people tend to focus very sharply on the cases that come out. But I think each of these cases turns heavily on its facts. Facts matter, advocacy and strategy matter, and every case, as everybody here knows, every merger case tends to have its unique set of facts, so you've got to be very careful about overreading a couple wins, couple losses here or there. I think when you look at these two cases, they're different in very important ways, and each of them has some points in it that are worth thinking about in a broader context. Sabre Farrellogic's case, there I think actually the government loss isn't as surprising as some people might think. And that's simply because cases involving circumstances where the merging firms aren't really competitors for most of what they do, and where in fact the competition may largely be a nascent form of competition or some very narrow set of competitive overlaps, if any, are hard. I mean, those are challenging cases for the government. They're challenging because you don't have a record of vigorous head-to-head competition for the most part. And so when you look at that kind of case, that's always a challenging case to bring, and it's a challenging case to litigate. And I think when you look at the decision, that and some complicated issues about market definitions, some of which relate to multi-sided platforms and some of which don't, were critical in the case. I think, again, when you think about the context of very limited competitive overlap, problems with the market definition, the loss isn't that surprising. I do think that there are some aspects of the decision where I think the court was just simply confused about the American Express case. I think the notion that American Express holds as a matter of law that in a two-sided market, the only competitors are other two-sided platforms is just plainly wrong. That's not what the Amex court said, and I think that's an area that the court was just frankly confused about. I'm not sure that mattered to the outcome, though, when you look at the rest of the points of that decision. T-Mobile Sprint, I think, was a more surprising loss. It technically wasn't a DOJ loss. DOJ settled that case. This was the states. But it was a surprising loss if you just look at it from the outside, because there you got a 4-3 merger with direct horizontal competitors in an industry where there had been previous transactions that were blocked. But facts matter. I mean, that was a case where the parties put together a very compelling general dynamics / flailing firm type defense where they argued based on very specific facts having to do with the nature of the assets that the firms had, that Sprint had and that T-Mobile had, and the nature of the business problem that Sprint faced, that Sprint's going forward viability as a competitor was really not anything like what you would think simply looking at market share numbers, and in fact was questionable as to whether Sprint would be viable at all going forward. On the contrary, they were able to show that if you took the assets that Sprint possessed and combined them with the T-Mobile platform, the T-Mobile assets, you would make a much more formidable competitor. Now, a lot of us have heard many times this notion that a strong third is better than a weak third and fourth. And a lot of times that argument doesn't get you anywhere. But in this case, the parties showed it with some very concrete and very specific facts. And I think the takeaway from that is largely that when you have the right facts and you put them together in the right way, then you can win a merger challenge.
So thank you for correcting one misspeak on my part, which is the fact that it was the states that lost the T-Mobile Sprint case and not DOJ. DOJ did in fact settle, and its settlement was also approved in the midst of the COVID crisis. I wonder though, I mean, I think what I found interesting about the decision, Judge Marrero's decision, was, that he defined the relevant market in a way that created a presumption, and then found the presumption overcome by really facts and impressions I'm oversimplifying somewhat, as opposed to any of the economic analysis that either of the states or the parties put in, which I thought was kind of an interesting and different take.
Yeah, I agree. I think, first of all, the government losing a case when it has the presumption is in a horizontal merger setting is fairly uncommon. But again, presumptions are presumptions, right? They're not conclusions. And so the idea that the government should never lose a case where the presumption exists, I think, you know, obviously this court showed is not correct. And I think that makes sense. I mean, again, when you think about the role presumptions play in litigation, they really have to do with what's the framework that you're using to evaluate the situation as a judge, and how are you going to interpret facts? They don't dictate the outcome. Insofar as the economic testimony, you know, this is something that people have thought about for years. I think Tom Rosh actually, when he was a commissioner of the Federal Trade Commission, complained about this quite a bit, where he said, look, you know, judges just aren't going to do anything with lots of Greek letters that are put in front of them in complicated equations. And, you know, I don't necessarily agree with the position that Tom took about those kinds of things. I think economics is incredibly important. But I do think it's true that when you have good economists making credible arguments simultaneously to a judge, one on one side and one on the other, then there's probably a tendency for those to kind of moot out, and for the court to then look at other facts that, you know, perhaps are more comprehensible to somebody who's a lay judge, someone who doesn't spend all their time dealing with antitrust enforcement. And instead they're looking at things like business documents and what executives say, things about how cell phone networks work, for example, in the T-Mobile case, that are a lot more readily understandable. And so, you know, in essence, I would say when you have a tie at the economic stage, then the facts are going to assume increased importance. I don't think that you're necessarily always going to get a tie at the economic stage. I think, for example, in Sabre Farologics, it's not obvious to me that there was a tie at the economic level. But I think when you get very solid economic testimony on both sides, then it is fairly likely that the decision-making is going to move off to different grounds.
Reaffirming the age-old adage that facts matter. Olivier, I'd like to move over to you for a moment and talk a little bit with you about the consolidation in the telecom space, which is obviously hardly limited to the United States and you know, raises lots of complex policy questions. What issues is the Commission encountering in the space today, and how are you addressing them?
Yeah, thank you, Renata. That's a very good question. I would say if I base myself on our most recent practice, I would identify maybe three essential issues. The first one has to do with the legal test. I mean, we're criticized by some in the legal community for having a prejudice against 4-3 mergers, because it happens that we've been intervening in 4-3 mergers recently. Cases in which the Commission found that the transaction was have given rise to a significant reduction of competition due to horizontal unilateral effects, but short of the creation of strengthening of any dominant position. And this has given rise to a debate, which is still very lively, on how to interpret the legal test. So that's the first issue, legal test for horizontal unilateral effects. So some claim that the Commission has lowered the intervention threshold on the basis of the bias just referred to, alleged bias against market structures with 3 players. So first of all, there is no bias. It's simply so happened that the cases in which we intervened had this feature. But more generally, this is an issue that is at the heart of the 2004 reform of the EU merger regulation, where we introduced unilateral effects. And the courts have not providing clarity in this respect so far. not even when we had a few cases, but the court never pronounced really clearly on this issue. Our stance, consistently expressed in all recent merger cases, and in particular in the telecom sector, is that there is no magic number. Telecom mergers, like any other mergers, are assessed on a case-by-case basis. Our assessment is grounded in economic literature. It is based on the extent to which the elimination of head-to-head competition between the merging parties would significantly affect the competitive dynamics overall by leading to price increases by the merging party or their competitors, or by affecting actually any other parameter of competition. So the fact that the Commission intervened in a number of 4-to-3 mobile merger does not mean that the test applied by the Commission is so broad that any 4-to-3 mobile-to-mobile merger would be automatically prohibited. And by the way, we cleared the Dutch mobile telecom merger between T-Mobile and Tele2, because the facts in that case were such that we did not consider a significant reduction of competition was likely to arise from the mergers. The second takeaway, I would say, has to do with efficiencies. Telecom operators in the recent merger cases we've dealt with have pleaded for a more lenient application of our rules to allow in-country consolidation, arguing basically that this is a necessary condition to enable more investment in telecom infrastructure across the EU. But what we found when we assessed efficiency claims in merger investigation is that we never found actually any evidence that consolidation would significantly spur investments. Competition and customer demand appear to be rather the key drivers for investment in these cases. And we also found that less anti-competitive alternatives to mergers could be constituted by other practices, like, for example, network sharing agreements between companies that can bring efficiencies, benefit consumers by accelerating the rollout of new technology without reducing the number of players active on the market, even if not all network sharing arrangements are beneficial or pro-competitive. The third takeaway, and last, has to do with failing firm defense. Although we were never faced recently with a real failing firm defense, and merging parties have never argued really failing firm. Instead, they often submitted claims that the competitive constraints which would have been exerted by them in the counterfactual would have diminished for different reasons. Network capacity issues, for example, in the 2016 UK case, or financial constraints in an Italian case also in 2016. But in no case the Commission has found that the merger would have had less anti-competitive outcome than in the counterfactual. The exception, there is one, is again the 2018 Dutch mobile merger, where, however, not only the significant uncertainty concerning Tele2 future role as a competitive force in the Dutch market played a role in decision for unconditional clearance, and it was a 4-to-3, as I already referred to. And also other case-specific evidence led to that finding. So we have this sort of counterfactual theory, this sort of low-key failing firm defense that arises in telecom mergers more than otherwise. I'd like to say a last word to echo something Rebecca said in the initial remarks, is we do not see either any case for relaxing the standard for reviewing mergers because of COVID-19.
Thanks, Olivier. Bruce, the American Antitrust Institute recently issued a report on the Trump administration's enforcement record. Do you have any thoughts on the contents of that report that you'd like to share?
Yeah, I've not read it, though.
So Renata, as you might guess, I have a number of thoughts on it. I think, first of all, I found the report disappointing because I think AAI has some really good people in it that I have a lot of respect for, and I think they could have done a much better job on this report had they focused more closely on the actual data. I think, first of all, this overall claim that they make that there's some decline in enforcement is demonstrably untrue. I'll focus on the FTC. I can't really speak for the DOJ. But insofar as the FTC, if you look over the last 3 years, what you see is a really high number of litigations, a really high number of trials. I think at one point I estimated that FTC staff spent 1 out of every 5 days of the last 3 years actually in trial. You see a record of really aggressive cases with profoundly important results, like the AbbVie case with the highest competition disgorgement in history, brought on a sham litigation theory. The Reckitt-Benckiser case, where there was disgorgement on a product hopping theory. The Autobot challenge, which is a challenge to a consummated merger that raised nascent competitor issues like the CDK Automate challenge and the Illumina PacBio challenge. The Banco case, which was a very aggressive challenge to an agreement not to discount to GPOs. And of course, the ongoing SureScripts case, which dealt with monopolization of multi-sided transactional e-prescription platforms. So these are really aggressive cases. When you look at the data analysis that AI did, they actually don't disclose much about their methodology, so I had to try to reverse engineer it. But there's a couple of basic errors that just jump right out at you. For starters, based on the report's citations, they miss the majority of the current commission's tenure. They appear to have looked at the years 2016, 17, and 18, which misses half of the current FTC term, and most of, for example, Commissioner Slaughter's term just isn't covered in their data. So I think it's kind of challenging to make any broad statements about enforcement when you're not looking at the majority or at least half of the current commission's activity. They also do some kind of obvious measurement errors. So in the 3 years they look at, what they do is they say, well, there are very small changes over that period, and based on those small changes, we claim an overall decline in enforcement. But when you actually look at the numbers, what you see is the changes are tiny. They're consistent with normal variation in enforcement levels, and they're consistent with decade-long trends. So for example, if you look at a decade-long trend line, you see a continuous line. You don't see any change running between 2016 to 2018. And just here's a couple of examples. During that period, the number of second requests issued by the FTC was 20. In 2016, there were 25. There were 33 in 2017, the majority of which was under the current administration. 26 in 2018. Does that sound like a big change? Number of merger challenges, 22 in 2016, 23 in 2017, 22 in 2018. Number of merger litigations, 5, and then 2, and then 5. Now, the percentage of deals that got a second request fell slightly from 3% down to 2.2%, but that is squarely consistent with a decade-long trend line starting at 4.5% in 2009 and then falling steadily over that time as, by the way, the number of filings rose by almost the same measure. So you see a trend line of percent of filings getting second requests falling slightly, number of filings rising slightly. And parenthetically, the 2017 to 2018 trend, where there was slightly fewer second requests, you only had 59 additional filings between 2017 and 2018. So normally you would only expect those to generate 1 or 2 second requests. The variance to that, between that and 0, is probably within the standard error margin. Additionally, you could get similar results if you just picked sets of years within the Obama administration. So for example, if you looked at 2013 to 2015, the percentage of transactions that got a second request fell from 3.7% to 2.7%. If you looked at FTC merger challenges in the years 2012 to 2014, they fell from 25 to 17. So I could pick 3 random years out of prior administrations, and really any administration, and say, well, if I'm going to do a trend based on start and end of those 3 years, I can basically tell any data story I want, which, by the way, is why when you do statistical work, the kind of thing that they did is considered bad work. There's actually a methodology where you can use longer-term trend lines to develop conclusions about what's actually happening, which they don't appear to have done. So overall, the data, when you do good and serious data work, doesn't support their claims, and the facts actually show otherwise.
Thanks, Bruce. It's clear that you don't feel at all strongly about this topic. Commissioner Slaughter, would you like to weigh in on this topic?
Sure. And I have long since learned not to even try to go toe-to-toe with Bruce on numbers like that when he has clearly stacked them up so well. But I had a couple of thoughts I wanted to add to what he said. The first, actually, is something I should have said right at the beginning of talking that I still am forgetting to say, which is that my remarks obviously represent my views and not the views of the commission as a whole. Or the other commissioners. So that goes for everything I already said and everything I'm about to say. And I actually don't want to delve into the AAI report specifically, other than to say, I think it's a good thing as a general matter when advocates across the ideological spectrum work to hold government's feet to the fire and challenge the work that we're doing and keep us accountable. And we should be accountable for the work that we're doing, and we should be able to explain why we make the choices that we make. And that's a good thing. So whether it's to agree or rebut, I'm happy to see debate about antitrust enforcement, the levels that it's operating at and where it should be. A couple points that I will make. I think Bruce did make a really good point about a number of cases that have been brought recently. And I will tell you from an at least anecdotal and experiential level, the commission had an extremely busy fall and filed a lot of cases that I was really excited and enthusiastic to support, including our challenges to Illumina PacBio. The SureScripts case obviously preceded that, but there were a whole number. And I'll point out that the commission held its first virtual commission meeting a couple of weeks ago, preceding a vote to challenge the Altria Jewel transaction. So there is a lot of stuff happening. I also tend to think we should always be looking at what more should be happening and how more should be happening, both on merger litigation and on conduct, which also reminds me of the one additional point that I wanted to make earlier about COVID response, which is that in addition to thinking about market structures, one thing that the agencies have said that they're thinking about, and I think is really, really important, is to be on the lookout for anti-competitive conduct like wage fixing, that we've seen some anecdotal reports of in the wake of, or in the, not even the wake, in the experience of the coronavirus pandemic. So anti-competitive conduct remains a source of high concern, separate and apart from the kinds of competitive collaborations that may be acceptable to deal with pandemic response.
Sticking with merger enforcement, but shifting gears a bit, Renata, if I could ask you to indulge me to take off your moderator hat and put on your speaking hat. I'd like to ask you about the DOJ's recent novellus Solaris matter that a lot of us have been discussing, and in particular, the arbitration procedure that DOJ and the parties agreed to use to resolve that matter. What are your views on that case and the pros and cons of this new development? Is this a one-off experience, or is this the next big thing?
So I think it was a really interesting thing to do, and I think the goal of using arbitration has to be to move things faster. That case moved quite slowly, honestly. So I was thinking I would say, well, it moved things faster, but the transaction actually started in 2018, and it took, I think, more than a year for DOJ to file a challenge in September of 2019. But to get from September of 2019 and to a decision in early 2020 that's pretty good. And I think the problem, to the extent there is one, is that there's not a lot of transparency into what happened in the arbitration. That's one of the great things about filing in an open court, and barring confidential information that can't be shared publicly, the public, the press, practitioners, everybody gets to see how the cake was made. And I think the real downside of the arbitration piece is that you don't really get any insight into that. So you miss a lot of the texture of the case and what really made a difference. I also think it seems like it would work very well in a situation like the one that DOJ used it in, where you have a very clear dispute about market definition and a clear answer as to what you would do if the market is defined one way or the other. There you saw, if the market was defined one way, no problem. If the market's defined another way, a very clear divestiture has to be made. And that seems like a fact pattern that's quite well suited to use of this somewhat, truncated procedure. So whether we see it again, I think is going to be, both up to the parties and whether they want to agree to it. I think that will depend a bit on how the parties who went through it in the Novella Solaris transaction felt about the process, and whether they felt like it worked well for them, because that will work its way around the bar and amongst clients. And whether or not you find a fact pattern that kind of suits itself well to that process. But I think it was an interesting thing to try. I wish there were more transparency into what happened. And I guess we'll have to wait and see whether people use it again.
Is it your sense that the details of this, few that they are still working their way through the grapevine of the antitrust bar, or has it been out there long enough that you've actually received any inquiries from clients who are interested or maybe even turned off?
So clients are definitely interested, because it does hold out the promise of moving something more quickly, when clearly the fundamental debate between the parties and the agency is around market definition. So yes, I've gotten inquiries from clients about it. I haven't actually heard many reports from sort of the rumor mill within the bar about how well people who went through the process felt like it worked, but I don't know if others on the line have heard about that.
I don't think so at the moment. Becca, turning back to you for a second, process questions have arisen again with respect to the FTC's Part 3 administrative proceedings. At the moment, as in times past, there have been some criticisms and lately even some controversy and legislative proposals. What are your views on the role of the Part 3 proceedings, and do you foresee any changes on the horizon?
I think we start from the premise that Congress very specifically granted us an administrative proceeding and directed us to use it for particular reasons. And in fact, there are good reasons to use the agency expertise to work a case through in Part 3 that may not be best suited for federal court. And I'll actually piggyback on some of the stuff Bruce was saying and others were saying earlier about recent antitrust losses in federal court. I have a slightly more cynical view about what we can take away from some of those losses. I think that I wouldn't always describe the economics as necessarily an actual wash, but sometimes they are presented with a lot of hand waving in a way that it's hard for a generalist judge to see them as other than an actual wash. And that's complicated. So if we want to rely sometimes on really detailed economics, maybe a more expert tribunal is a better place and a better way to do that. I also think that some of the other, in addition to the antitrust decisions that have been pretty disturbing recently, there have been a whole number of other federal court decisions that have challenged our ability to get disgorgement of ill-gotten gains and use our 13B authority. And while I think that those decisions are wrong and should be clarified either by higher courts or by Congress, in the meantime, I think it's incumbent on us to think about how we might better use the other tools that we have, including the Part 3 process. So I think I start from the premise that Part 3 cases aren't the end of any litigation. They're usually the beginning of litigation, because even after a case moves through Part 3 at the FTC, it can be appealed to a federal court. So it's not like a unilateral single say on what happens by the commission. And those federal court decisions pretty broadly tend to uphold what the FTC has done where we bring those cases, even though we don't do it all that frequently. So look, people don't like being sued. When they get sued, they tend to challenge not just the substance, but also the process of the suit. And I understand that. And we can and should defend the process that we're using. I will also say one of the things that I really appreciate about being at a 5-person commission is that we do have a whole range of viewpoints among the commissioners. I think probably for the benefit of America and occasionally the frustration of our staff. And when you get through the commission with a majority vote, you really have to look at issues from all sides. And I don't think there's I have gotten no sense of rubber stamping in either direction of the commission by staff recommendation, by the commission of staff recommendations of what we should be doing. I think there's really careful scrutiny applied. I think that is applied in the first instance when we decide whether to file a case in Part 3, and then everybody is very respectful of the wall while Part 3 cases are being litigated, and the same scrutiny is applied if cases reach us on Part 3 appeal. So I will admit that I thought before I got to the FTC, I found the structure of Part 3 sort of perplexing and surprising, but I have come to really appreciate it as an opportunity for good development of the law if it's used responsibly and well.
Okay, I think I'm going to move us over to Kent to talk a little bit about the consumer welfare standard, which has obviously been a very hot topic, and there's been no shortage of commentary on whether it's the right standard and new economic thinking, and how it applies to new technologies or new industries, and really whether the consumer welfare standard is doing the job that it should be doing in terms of how people think about antitrust enforcement and when enforcement is warranted. So Kent, you and Google have been participating in this debate, and not just as spectators. Based on your experiences, what are your views? And are there different or better standards to evaluate or measure competitive effects, and what the market dynamics are? How are you guys thinking about this debate around the consumer welfare standard?
Sure. I mean, just for starters, obviously the consumer welfare standard, the notion of testing to see whether or not a given development helps people, has been a guiding principle for U.S. competition law for 4+ decades now, through both administrations. We think it has tended to encourage innovation, lower prices, and create the business certainty that you want to encourage investment. I think at the other end, you can go too far in substituting individual policy preferences in ways that become too subjective or unpredictable or even subject to capture. And there's an inevitable trade-off there. If you focus too much on something else, that implies you're less focused on what's helping consumers. I do think there's a happy medium that you can adopt what I think of as a holistic consumer welfare standard. So it's not just a question of lower prices, but also limits on output, lower quality, loss of innovation, those kinds of factors that are appropriate part of the review of the competitive process. And I think that's really where antitrust law has its core role, where it has a comparative advantage, which is looking out for consumers and competition, rather than protecting competitors from legitimate, more effective, or more innovative competition. There's always a danger that antitrust, because it's so broad, can turn into a backdoor industrial policy, or turn into a tool for sorting out business disputes. And the risk of that, obviously, is that you deter innovative companies from competing on the merits. There are other disciplines that do address other policy goals, as they should. For example, we've said for years, it would be great to have a comprehensive federal privacy legislation in the United States, along the lines of the GDPR in Europe, to align privacy standards that we have. But we think the consumer welfare standard, on balance, has promoted innovation, has lowered prices, has increased choices for people, and has encouraged more investment in research and development than we've seen in any other industry. I can speak for Google. We've been one of the 2 or 3 leaders in R&D spending for many years. I think we spent $26 billion in the US alone in 2019. And we're continuing to see dynamic competition, both between the big companies and with new players. The fact that we're having this discussion on Zoom rather than on Google Meet or Microsoft Teams shows how a small company like Zoom can enter and succeed and make others scramble to compete with them. So that's the kind of entry and innovation that I think should be the hallmarks of a healthy competitive market.
Thanks, Kent. Olivier, I'm going to jump to you, because some of these same issues have arisen in the context of Article 102 cases, and what's the appropriate standard of proof there. What can you tell us about that and about how the Commission is thinking about this question that's circulating around the world about whether we're measuring harm to competition appropriately?
Well, there's many debates going on in Europe at the moment. We have a huge debate about which comes back every 20 years as to the relationship between competition policy and industrial policy. It's like the Loch Ness monster. It comes back from time to time. And that the debate is very much is a consumer welfare standard appropriate, or shouldn't we rather move to a total welfare standards? And certainly we in DG Competition stand firmly on the ground that consumer welfare is the appropriate measurement. But it's maybe important to to make clear what we mean by consumer welfare standards as defined by the European courts. It of course encompasses price, but also quality, innovation, and more broadly choice for consumers. And so, of course, when you have established such a sensible interpretation of what consumer harm means, then the next important issue is to determine the standard of proof that is required to find an infringement based on this concept of harm. And there as well, there is a very lively debate, and very recently, on whether, in light of the characteristics of a particular digital market, as Kent just explained, competition authorities should make a larger use of presumptions and shift on firms the burden of proof that their conduct has no anti-competitive effect or is justified by overriding efficiencies. I think this debate risks being a bit misleading, and of course it has indeed triggered some unduly alarmed reaction. A straight shift of the burden of proof, I think, is not possible, and I would not be in favor. I think in an antitrust case, the administration has to prove its case, and I'm afraid it will remain like this. I don't see all courts changing that standard and shifting the burden of proof. So the burden of proof, proving an infringement, rests on us. But this said, at least in Europe, we always have had the possibility to rely on reputable presumptions for a very, very long time. It's part of the legal framework. It is endorsed by the case law. We once had the presumption, I don't know if it's still good law, of dominance above 50% market share, for example. So there are a number of reputable presumptions on which we work. There is, for example, a presumption that exclusivity rebates are anti-competitive that has been endorsed Okay. On the other hand, the possibility of relying on reputable exemptions has always existed in EU law, has been endorsed by the courts in a number of cases. We have had, and I don't know if it's still good law, a reputable presumption of dominance above 50% market share, established by the European Court of Justice. More recently, we have a presumption of anti-competitive effects of exclusivity rebates, for example. So it's not all that black and white, I should say. So we intend to continue to base ourselves on this type of reputable presumption, basically. So we need to have these debates on the standard of proof in digital market. I think for one reason, and that is that these markets are usually characterized by, first of all, important network effects. And secondly, in the digital world, these network effects tend to deploy more quickly than elsewhere. And as a result, and because antitrust investigations are long, for good reasons, and for reasons that also link to the preservations of the rights of defense, we need to, we are very often late, and actually when we finally eventually prove the anti-competitive conduct, the damage is done. So that's the context in which I think this debate is taking place in Europe, whether we could find more effective ways to act more quickly. But I think a straight reversal of the burden of proof is not on the agenda.
Great, thanks. That's very insightful and gives us a good, helpful perspective on what's going on over in Europe in this area. Becca, what are your thoughts on this debate? Are there other standards, non-economic or otherwise, that should be incorporated into antitrust reviews of transactions? And how do you think about the tension between competition and privacy laws and policies, and how to reconcile those?
Consumer welfare means different things to different people. So I try to avoid what is the standard called and think instead about what are the harms we should be addressing and how should we be addressing them. And I think it is clear to me that current law, both statutory and case law, and agency practice allows for and even requires addressing harms beyond price increase. So output, innovation, all the kinds of issues we've been talking about. I think that is very much a part of our antitrust law and should continue to be a part of our antitrust law. Now, if our courts are getting it wrong and issuing decisions that curb enforcement potential in cases where there really is harm, for whatever reason, whether it's market definition or legal standard or presumptions or burdens, that is something we need to look at. And I think Congress is looking seriously at that and think about whether we need to shift the standards. I actually take a slightly, I don't know if it was a different view from Olivier, but I think looking at burdens is a valuable exercise to do. One of the things that has been surprising to me in the course of conversations with staff about potential enforcement actions is just how high the burden is on the agencies and how difficult it can be to meet, and what that means in terms of resource expenditure and likelihood of success, and then how those analyses then play into enforcement decisions. So I'm happy to have agencies continue to bring cases that they think are the right case to bring, even if they don't necessarily win because a court misinterprets the law or gets some substantive issue wrong. But I don't think that that's great outcome at the end of the day for America. So I would rather see the law clarified in a way that limits that. And then to your point about the intersection of competition and consumer protection or privacy specifically, I actually think this is one of the great strengths of the FTC, which is that we have expertise on both sets of issues. And I think we're living in a moment where they really implicate each other very directly. And so one thing I really want to see the agency doing and continue to do is make sure that we are looking at competition questions with a privacy and consumer protection lens and vice versa. I do not think these things are necessarily in tension, but I think they can affect how one crafts remedies or how one thinks about whether, you know, the implications of a privacy problem, for example. So that's a valuable expertise to have, and I want to see us applying it rigorously.
Great, thanks, Becca. Kent, do you have any thoughts on this question of intersecting policy issues relating or enforcement issues relating to privacy, consumer protection, and competition?
I agree. I think it's an increasingly important topic. Privacy is, in a sense, a measure of quality for digital products. We work hard to maintain increased trust in our users so they feel comfortable using our products rather than going with rivals. However, we have recently seen places where there's uncertainty about how to balance different competition and privacy goals. And sometimes companies can feel a little caught betwixt and between as we try and design engineering solutions. Obviously, there's been some talk about privacy regulations raising barriers to entry, but even beyond that, you know, we might try and improve privacy by limiting third-party access to data. But they're and that would be in line, I think, with privacy laws like the California Consumer Privacy Act or the GDPR that clearly envision limiting third-party data sharing, even as a legal requirement. At the same time, there can be a risk that limiting third-party access makes it harder for other companies to compete. So we would love the antitrust regulators and the privacy regulators to come together. And as Commissioner Slaughter says, the FTC has both of those responsibilities in the United States, and providing more guidance in this area so that we know we have a clear roadmap as to what we should be designing and building.
It's interesting. I think this issue is arising around the world where the more you strengthen privacy protections in terms of, you know, for example, the ability to transfer data and information across borders, there is then potential to impact how competition works within the borders where you're restricting data movement in and out. Any other? Go ahead.
And just more broadly, I think that's a key part of designing a smart regulatory structure where you're looking at the second and third order impacts of new rules and trying to take a comprehensive approach to working this. So we want to be solutions oriented about how we approach this and, you know, encourage research and development. And one way to do that is to have regulatory clarity wherever possible. It's not always perfectly possible. It's a fast moving sector, but we think that well-tailored rules that consider all sides of this are actually in everybody's interest and ultimately incentivize companies, whether it's through a regulatory structure or a co-regulatory structure, as we've seen in Europe in many cases, where we can work together with the Commission or national authorities, or sometimes self-regulation with appropriate incentives. That actually helps us move forward on all of these fronts, benefiting consumers and the competitive process.
Right.
As we're coming into our home stretch, Bruce, Renata mentioned the new proposed vertical merger guidelines by the US FTC and DOJ. Those were released to the public for review back in January. Can you give us some background about how this development came about and what your views might be on the guidelines themselves as they're proposed?
Sure. So I'll start by saying I think this is a great effort. I think it was really important to get guidelines, and this gets to how we got here or the background of this. Prior to these guidelines, we had a set of guidelines from the DOJ only and not the FTC, which everybody agreed were bad and nobody used. Although, as I'll mention in a minute, the courts didn't seem to have gotten that message. But so if you have bad guidelines that are out there that nobody actually uses, what are you left with? Well, the answer is what you were left with prior to these drafts was John Sallett's speech and my speech, basically, and then whatever you knew of the industry lore and mystique and secret information about how the FTC and DOJ actually do this. That's a really unsatisfactory state of things from the standpoint of the public, of really not having good transparency into actual agency views. So, and again, as I said, not everybody got the message. You saw in the ATT case, the court was citing the vertical merger guidelines, notwithstanding the fact that everybody agreed they were wrong and nobody used them anymore. So where does that get us now? Well, now we have a set of draft guidelines that are out for public comment, which I think people could, there are a lot of points that you could agree or disagree with about what the guidelines say. Vertical mergers raise complicated issues because you don't have the intrinsic competitive effect that you get in a horizontal merger, right? The effects are much more second order and complicated. And to the extent there is an intrinsic effect from elimination of double marginalization, you could argue that it points in the other direction, although there's an academic debate over that. So the issues are really complicated. I think that there are things in the draft guidelines that everybody could agree or disagree with, and I think there'll be a lot more debate about it. But I think moving in the direction of having that debate in the open in the context of developing guidelines is a good idea, and certainly is better than where we were before.
Becca, I think you're the obvious next choice in this conversation. I read that you had abstained from the vote on the release of the guidelines. So perhaps this is a good shot, but we're not quite home there yet. What are your views?
Yeah, so I share Bruce's view that it's time to update the guidelines. I think that that's an important effort, and I think it's a good thing for us to be doing. So I didn't want to vote against an opportunity for the public to comment on new guidelines and updated guidelines. However, I had a lot of concerns with what was in the first draft of the guidelines. So I also didn't want to endorse the proposal as it went out. We're still in the middle of a comment period, so I want to be careful about what I say from a substantive perspective, but from a process perspective, I certainly want to say I think we've gotten a lot of really thoughtful input that I know everyone in the commission is in the process of digesting as thoroughly as possible, and challenging, using the information in the commentary provided to challenge assumptions and think about whether there are different or better ways we could do things. I will also say, though, that this process started before the current pandemic situation. And I have thought from the beginning that one thing that is valuable for the guidelines to do, you can think of guidelines in two different ways. They can be an articulation of what we have done in the past, or they can be an articulation of how we intend to do things in the future, to the extent that those things are different. And I think this is a moment, as I said at the beginning, where we need to be thinking very, very hard and very, very carefully about the kinds of supply chain and market structure issues that are being revealed by the pandemic right now. And it is important for those thoughts to be part of an assessment of vertical integration questions as well as horizontal. So that's something that's important to me. I also think our highest priority at the moment needs to be enforcement. And as I said earlier too, getting our day-to-day work done is a challenge under these circumstances, even with the enormous dedication and heroic efforts of all of our staff. So it is important to me that we not rush through long-term projects that really deserve and need substantive attention when our immediate attention, as it is somewhat limited, really needs to be focused on ongoing enforcement matters.
And turning to you just for a moment, I mean, as practitioners, we are in the business of providing guidance and offering advice. On the receiving end, how does the prospect of a new set of guidelines come across to you? And are guidelines the best way to provide guidance for a client under the circumstances?
We welcome the process. We appreciate the thorough the thorough review, the openness to input that we've seen. Just to stress that these guidelines and clarity around this is really critical to the startup ecosystem, to a lot of the small companies that are out there. They're trying to build their businesses. We've built many of our businesses based on acquisitions of smaller companies, like the couple of small businesses that came into Google Maps, and then Maps ultimately becomes a service that's used through Google Search. That's offered an awful lot of value. And these kinds of acquisitions can let us scale to reach scale services to reach more consumers faster at lower costs and ultimately more innovation. In many cases, when we're acquiring small companies, they're what we call acqui-hires, just a quick way of onboarding new promising engineers. The companies we've acquired in our history have had a median number of 7 employees each. And those kinds of acquisitions also, on the flip side, help encourage venture capitalists to invest in startups because they provide a ready exit strategy at a time when the markets might be in turmoil. So if you have less of that, less investment means less innovation and fewer entrants and less overall startup growth. So, the other piece is, the other side of the ecosystem is that even though there's a lot of acquisition happening, there's also a lot of spin-out activity happening, formally and informally. Former Google employees have built more than 2,000 startups. That's many times more than the number of companies we've acquired, including companies like Pinterest and Instagram and Twitter, and a number of smaller companies that are still up and coming.
Olivier, let me just turn to you now. The DG Comp went through this process more than, I think, 10 years ago when it adopted its guidelines on the assessment of non-horizontal mergers. And at the time, Commissioner Cruz stated, the majority of vertical and conglomerate mergers do not raise problems, and they can bring about efficiency gains that benefit both businesses and consumers. At the time, I think this was sort of viewed as received wisdom, and I think part of what's going on in the discussions around the new draft vertical merger guidelines in the U.S. is, a question about whether that received wisdom is actually true. So where is the Commission on these issues today, and has its views changed since the time that it looked at its non-horizontal merger guidelines?
Well, thank you for that question, Renata. Indeed, we have a bit more than 10 years experience in implementing what we call non-horizontal merger guidelines. And maybe what I see when I read the draft vertical merger guidelines in the US is quite a fair amount of convergence between our jurisdictions in many respects. The US analytical framework of foreclosure and raising rivals cost seems to me to be quite similar or in line with the ability incentive effect framework of our non-horizontal merger guidelines. Both texts explain why access to competitive sensitive information may in certain circumstances affect rivals and their competitive constraints. And also both texts acknowledge that by bringing together complementary products, vertical mergers provide substantial scope for efficiencies. Well, as you said, I mean, our guidelines date back to 2008, and we have applied them in very, very numerous merger cases so far. What we do is we distinguish between coordinated effect, non-coordinated effect that may be caused by non-horizontal mergers. Non-coordinated effects may principally arise when non-horizontal mergers give rise to foreclosure. And in order to assess the likelihood of anti-competitive foreclosure, the ability incentive effect framework that I just referred to is used for the competitive assessment. Non-coordinated effects may also result from the fact that by vertically integrating, the merged entity may sometimes gain access to commercially sensitive information regarding competitors. So when investigating mergers, DG Comp runs very, very much case-by-case assessments. As set out in our guidelines, the fact of each individual case will decide whether vertical mergers raise concerns and whether remedies are needed or whether they do not raise concerns. And in that respect, the Commission does not apply a presumption. Maybe to close on this and to answer your question, finally, I've asked my colleagues to give me the statistics since over the last 5 years, since 2015. We have intervened in 117 cases and I spare you the breakdown, but the relevant thing is we found vertical effects in 14, and conglomerate effects in 6. So I think the prognosis of Mrs. Cruz appears to be quite confirmed indeed.
Olivier, thank you for that. And at this point, I'd just like to offer my thanks to Renata and all of our speakers for taking the time to participate in this unusual and hopefully unique hot topic session of the spring meeting. Thanks again, and be well to all of you. John, back to you.
Okay, great. Thanks, Brian. Thanks, Renata. Thanks, panelists. Really great discussion. Matthew, Christina, really interesting video. Matthew, let's start with you. What are some of your takeaways from today's panel?
Well, as you say, John, it was a very interesting discussion. I thought that the real headline is that enforcement is continuing, during the pandemic. Obviously, the hot topic of the moment is the pandemic. There are necessary changes to procedure. Olivier Goersentent from the European Commission was talking about what they're doing to make sure merger control procedures are continuing so far as possible, encouraging people really to delay filings if possible. He mentioned state aid, which is, of course, the specific EU regime for controlling funding to companies from governments. And it is really remarkable what they've done in that area in the past few weeks. The number of decisions taken extremely quickly over weekends, which Olivier was referring to, has truly been incredible. We will talk some more about specific substance, but one thing I did note that Olivier mentioned, which was really in passing, was that before the pandemic came along, the Commission, he said, had apparently started to think about specific guidance on decarbonization initiatives. That is, of course, climate change is surely a hot topic, even greater than the pandemic reaction. And I think it's an interesting concept, maybe to come back to in the future, as to what extent the way that competition and antitrust law has responded to the pandemic could be perhaps a model for future arrangements and cooperation in relation to climate change response. That's a bit off topic, but I thought that was an interesting comment that he had made. Just one final point was on the comment, the discussion about consumer welfare and the burden of proof. I think there was a clear statement from Olivier that the Commission does not see any argument for shifting the burden of proof in requiring dominant companies to demonstrate that what they are doing in the behavioral space is a good response or is justified by efficiencies. So that was a fairly clear steer, the Commission's viewpoint, at least from the antitrust law enforcement side of things on that issue.
The very interesting insights, Matthew. The climate change and the sustainability questions are things that we have taken on a little bit in our Curious Amalgam, and I think we should probably plan a podcast in the future where we talk about that from the perspective of the European Commission. We've done one from the United States. But very interesting points. Christina, what are your thoughts?
So certainly want to echo everything that Matthew has said. I thought it was an incredibly informative and interesting panel. There was a lot of activity and enforcement happening before the pandemic hit. There was reference to the Sabre Farologic litigation, the T-Mobile Sprint litigation, the Novella Solaris arbitration, and it's good to hear that we're continuing to think about how all of these events impact our practice. There was reference to the draft vertical merger guidelines as well. And I think in general, crises provide an opportunity to refine or put into perspective how we should be thinking about these issues. You know, there's always been this ongoing debate about what's the right legal standard, about the right presumptions, about the right venue of resolution, and how to move the conversation forward. And I think what was great about this panel is, one, we're all sort of sitting in this interesting time, and that adds a different lens to how we should be thinking about the issues. But the panel was just incredibly diverse. We have folks from enforcement here and abroad, individuals from private practice, as well as, I shouldn't say private individuals, but private parties, third parties, who can lend their view on all of these issues. And I thought that was really informative.
Christina, Matthew, thank you for coming in. Just as a reminder, we will be continuing with the Our Curious Amalgam regular podcasts starting back on Monday, May 4th. And we're going to keep going every Monday until somebody tells us to stop. Christina, Matthew, thank you for coming. Thank you for attending. Great comments. We want to thank the panelists, Renata, HESSE, Brian GRUBE. Thank you so much for all the hard work you did in setting it up. Thank all the panelists for coming in and giving us their time. And mostly, we want to thank you, our listeners. We appreciate you tuning in to the virtual spring meeting. And until we speak again, please be safe and be well.